Welcome back to Criminal Law class. In today's class, I will explore one of the most fundamental aspects of criminal law, mens rea, and how the police and prosecution seek to prove it. Mens rea roughly translates as guilty mind. However, it is better to think of mens rea as the mental element of a crime or the state of mind. As I explained in previous criminal law classes, most criminal offences are made up of both the actus reus and mens rea, unless the criminal offence is one classed as a strict liability offence, which I explained in later criminal law classes. So take the offence of theft as an example. The actus reus of theft contained in Section 1 of the Theft Act 1968 is made up of three elements: appropriation, property, and belonging to another. The mens rea of theft, or the guilty mind or mental element of theft, is made up of two elements: dishonesty and an intention to permanently deprive. Now, one of the most important roles of the police is to gather evidence, not just evidence whether or not the accused has the actus reus or guilty act of a particular criminal offence, but also evidence whether the accused has the mens rea for a particular criminal offence. This can be quite challenging, especially when, like anyone, the police cannot read minds and the accused might deny they had the mens rea of the offence. So how do the police and prosecutors go about seeking to prove the defendant's mens rea? Let me give you this example of a nightclub incident where the accused is arrested for a Section 18 grievous bodily harm offence. Now, the mens rea for a Section 18 grievous bodily harm offence is the intention to cause grievous bodily harm or really serious harm, which I explain in more detail in later criminal law classes. The police might gather evidence about the accused's intention to cause grievous bodily harm from five key sources. 1. The police interview, where the defendant might answer police questions and say in response, "I wanted to put the guy in hospital." 2. Witness statements, what the accused was seen to do or say during the incident by a witness. So the witness might have first-hand knowledge of the defendant throwing a chair and shouting, "I'm going to put you 6 feet under." 3. Medical reports concerning the injury, e.g. a fractured jawbone consistent with a Section 18 level of injury, but also indicates the amount of force used consistent with an intention to do really serious harm. 4. CCTV footage, which might show the defendant using a chair as a weapon and using the chair repeatedly while the victim is lying on the floor. And 5. An exchange of messages before and after the incident, indicating the deliberate and planned targeting of the victim. There are lots of sources where potential evidence might come from, which the police and prosecutors might seek to gather in any given criminal case. Remember, prosecutors and defense solicitors look at the police interview as the starting point to discover the mind of the accused and whether they had the requisite mens rea or not of a particular offence. In later criminal law classes, I explain how the law also aims to help jurors in the absence of a clear confession from the defendant, which is all about how they can ascertain the defence mens rea and the guidance provided to jurors from the Section 8 of the Criminal Justice Act 1967. In these next series of criminal law classes, I explore the most common mens rea which feature in criminal offences: intention and recklessness. For now, thank you for watching. Feel free to comment and don't forget to follow and subscribe for more.